Call the list.
Application.
That is permitted to mention regarding 163A matter, lower court.
Yes, Mr. Pal. Application for inclusion. Yes.
This is also for inclusion. Tribunal awarded 5 lakh under section 163. Only to accompany. Yes.
No. What happened?
Under section 163A, London Tribunal awarded 5 lakh retrospective effect has been given, and insurance company preferred the appeal for reducing the same. That should not.
Who is for the insurance company?
Mr. Pahari is appeal.
Mr. Pahari. See, inclusion in the list.
Inclusion in the list.
My lord, same here, my lord. Inclusion.
Okay.
My lord, on the last day, my lord had fixed one matter for final hearing on the 17th of May, where the money was not deposited. Stay was given, but without
Yes.
My lord was pleased to fix it on 17th of May. FMAT NV 16106 of 2024. Now, my lord, I have filed one cross objection for 77. I have already served the other side. My lord, let that be listed on the 17th of May along with the
17th of May.
Yes.
To be mentioned tomorrow.
To be mentioned tomorrow. I'll give the slip.
Yes, give the slip.
My lord, may I be permitted to mention one case of 163A? This was inclusion in the list.
Okay. Call the list. No. Read the list. Pen করে দিই। চেক করে। ছাড়। The paper. থেকে মতো করে থাকে। Give me the LCR. May I file with service? Yes, paper book has been already filed. Paper book has already been filed. Two grounds I have taken, my lord. First ground, my lord, regarding my lord, driving license. Second is quantum of compensation. This is an injury case, my lord. My lord, kindly consider paper book, my lord. Yes. My lord. Regarding first issue regarding driving license, my lord. Regarding driving license, first issue, my lord, page 25. Can you come to my lord, page 25? Or paper book. Page 25, you have got it, my lord. Page 25. DW? DW2. 2. Page 25, my lord, kindly come to page, paragraph 3. Yes. Paragraph 3. I state that on the date of accident, that is on such and such, Mohammad Fairaz Ahmed of Panagar Bazar, Purbo Bardhaman, the accused driver of the involved vehicle, being registration number such and such, oil tanker, was not holding a valid driving license as he was authorized to drive LMV non-transport MCWG, that is motorcycle with gear, transport LTV and MGV. 8GB driving license bearing number such and such from 15/6/2020 to 14/6/2025, which was issued on 27/11/2001. The mentioned driving license was again renewed on 15/6/2020, whereas the date of loss is 11/2/2015. This to my knowledge. Uh, Next page, my lord, page 26. Paragraph 5, I submit that according to the terms and conditions of the insurance policy issued by our insurance company, the insured registered owner of the involved vehicle has made a willful breach of policy conditions by allowing the appropriate person to drive his oil tanker. The offending vehicle was the oil tanker without having any valid and effective driving license. This is true to my knowledge. My lord, uh, RTO and DW one is my lord RTO. The page 24. Page 24.
Who
Page
is
20,
DW2?
DW2 is matlab,
Assistant manager.
officer of Reliance General Insurance Company, insurance
Okay.
company, and DW1 is the matlab, officer of Motor Vehicles Department.
Yes.
As per the document that DL issued on 27/11/2001 for driving LMV, motorcycle, transport vehicle, etc. New DL for driving transport vehicle was issued on 27/11/2001 up to 18/6/2020 from the MV Authority of Burdwan. DL was renewed from MV Authority of Purbo Medinipur as per record. The DL for driving transport vehicle was valid on 11/2/2015. My lord, kindly come to my lord, consider the Motor Vehicles Act. Motor Vehicles Act. Section 14.
Yes.
Section ঠিক আছে। Section 14, my lord, proviso to 2A. Section subsection 2, a driving license issued or renewed under this act shall, in the case of a license to drive a transport vehicle, be effective for a period of 3 years. Thereafter, proviso, provided that in the case of license to drive transport vehicle carrying goods of dangerous or hazardous nature, be effective for a period of 1 year, and renewal thereof shall be subject to the condition that the driver undergoes 1 day refresher course of the prescribed syllabus. There is this defined kind of driving license, not heavy goods vehicle or medium goods vehicle. Not the oil tanker is a hazardous goods vehicle, and for driving this hazardous goods vehicle, there are the specific provisions, and effective of such driving license is for 1 year. Is 1 year. Other non-transport, 5 year, 20 year, but in case of hazardous goods, that is for 1 year, and there is a specific provision that what would be the driver undergoes for 1 day refresher course of the prescribed syllabus. Therefore, the oil tanker becomes a hazardous goods vehicle, and the driver only capable to drive transport vehicles and non-transport vehicle. The findings now the
Whether oil is the hazardous goods?
yes, oil tanker is the hazardous goods vehicle.
Is there any schedule like that?
My lord, my lord, provides to say, my lord, transport vehicle carrying goods or hazardous nature.
Goods of hazardous nature.
Yes, goods of hazardous nature.
Whether oil come under the goods of hazardous nature?
My lord, in the definition, my lord, there is no, I do not find any. But oil tanker is, my lord, another provision, my lord, definition of, my lord, hazardous goods vehicle.
Yes, proceed.
My lord. Now, my lord, kindly come to, my lord, page 34, the findings of the learned tribunal. The third paragraph. 34, my lord, third paragraph.
Yes.
Yeah, Mullah, on the other hand, OP number 2 insurance company examined two witnesses in this case as DW1 and DW2 and produced the extract copy of driving license of accused driver and copy of insurance policy, and the same have been marked as exhibit A and B. Mullah, just a minute, Mullah, that Mullah, can you come to page 192? Page 192, the extract of driving license, DL.
Yes.
It's a middle portion validity details. Middle portion, Mullah, validity details, left hand side, Mullah. Yes, non-transport, transport. Hazardous, no. That extract of the driving license has been, Malad, exhibited before the learned tribunal. Malad, thereafter, Malad, it was argued at length, and Malad, that Malad Sharan Singh and other relevant judgment also placed. Malad, now kindly come to straightway page 37, the final observation of learned tribunal. Page 37. Several judgments has been, Malad, placed, Malad, in this regard, Malad, page 37, Malad, fourth line from bottom. Fourth line from bottom.
Yes.
Page 37, fourth line from bottom. Therefore, the trend of all the judgments of the Honorable Supreme Court is to ensure that where the damages is to a third party, the direction is to get insurer to first satisfy the award and then recover from the assured. Thus, in the present case, even if OP2 has proved its defense, it is still liable to satisfy the award and subsequently recover the amount from the assured. There was an observation, but ultimately, well, there was Learned Tribunal failed to grant any liberty to recover from the owner of the vehicle. Well, settled law. I have to pay first to the third party, the heirs of the third party or the victim. That I shall recover from the owner of the vehicle.
No specific order was there.
No specific order. In fact, your lordship will find, Balat, in the order in question, that is page 43.
Yes.
Page 43, Malat, order in portion. There's no specific order, Malat. Page 43, Malat. Your lordship got, Malat. This is my first point, Malat. As far as Sharan Singh and other relevant judgment, Malat, my client is entitled to get the recovery right from the owner of the vehicle after paying to the victim. This is my first job.
Yes.
Second count is my quantum of compensation. This is an injury case, my lord. Kindly come to page 9. first, page 9. Page 9. Page 9, malat, last paragraph. Page 9, last paragraph. There is the malat, page 9 is the malat, deposition of the victim, Sinchita Ghosh. Malat starts from page 8. In the last paragraph. At the time of accident, my salary was rupees 31 to 50 per month, and at present my salary has been little bit increased. But after the unfortunate accident, as I have lost my left leg, I cannot travel by bus or train, and to continue my service, I am compelled to travel by a hired vehicle from Batanagar to Dalhousie. So my additional traveling expenses is more than such and such. There is specific evidence that after the accident, his salary was increased. I'm coming to that. Next. Next, Malat, uh, page, can you come to page 13 and 14? Page 13.
Page 39,
No, 13, only 13, 1 3.
1 3.
Page 13, last paragraph. At the time of accident, I used to, that is the cross-examination of the victim.
Yes.
Malat, at the time of accident, I used to earn rupees 31,000 per month. I joined the job on 2/11/2015 after my discharge from the hospital. Next page
Yes.
14. At present, I earn rupees 38,000 per month. I hold the post of assistant manager, which was the same at the time of accident. There was no demotion, there was no decrease of salary. In fact, salary was increased from 31,000 to 38,000. My submission is there is no loss of income. Although here the victim has suffered permanent disability, but there is no loss of income. Then can come to page 20, 20. Two zero. 20 is the deposition of employer of the victim.
Yes.
Kindly come to second paragraph. I have brought system generated copy of Form 16 for the year 2014 to 15 of Shinchita Ghosh. The attested copy of the same is marked and such. I also brought system generated copy of payslip Shinchita Ghosh from April 2014 to February 2015. All the attested copies of the same are marked as such and such. Shinchita Ghosh was B.Tech, important. Shinchita Ghosh was B.Tech in chemical engineering. At present, she cannot do job at the factory due to amputation in her leg. She is transferred to the head office of the company at Kolkata as compensatory rule. Thereafter, in cross-examination, I am assistant manager of secretary and insurance. After the accident, Shinchita Ghosh remains in the same post as assistant manager, but her work is purely clerical now. Purely clerical now. The yearly increment of the employees depends upon their performance. The employees of the company has group insurance and medical insurance.
Yes.
Therefore, my humble submission, although there was a deposition of medical board that the victim lost her one leg, 70% permanent disability. But here maybe there is a permanent disability, but there is no loss of income. At best, she can get medical expenses, she can get general damages, pain and suffering, non-pecuniary damages she can get. But future loss of income, there is no scope. Dr. kindly come to page 40. Page 40. 40. Page 40.
Yes.
मतलब second paragraph. Second paragraph. मतलब 6 line. Second paragraph. 6 line from top. 6 line from top. That the sentence start that since the date of accident.
Yes.
Since the date of accident, the victim has been compelled to live her life with the help of artificial limb due to amputation of her left leg. It is further evident that the victim had to spend rupees 10,21,000 to purchase artificial limb, and the lifespan of the component of the artificial limb is more or less 5 to 6 years. As such, after every 5 to 6 years, the victim requires approx rupees 5 lakhs to change the component. More so, as an impact of accident injury, the victim has suffered loss of entire future prospect as an engineer and also her marriage prospect. Here, the findings, there's no evidence because that victim spent rupees 10,21,000. There's no evidence that
There is no evidence.
no evidence. What is why this observation has been made that after 5 to 6 years that artificial limb is to be changed and that another 5 lakhs will be incurred. There is no evidence. From where the artificial limb has been affixed to the victim, that company, there's no evidence. Only page 9. Can you come to page 10? Page 10. Page 10. You got it, Mal? Page 10.
Yes.
Page 10, bottom portion. Bottom portion, column number Roman 9. Column number Roman 9. Receipt for purchasing prosthetic limb for rupees.
Page 9.
Page 9. Sorry, I'm sorry. Page 10. Page 10. Next page. Page 9 is the deposition of page 10. Deposition of victim. Page 10.
Yes.
Page 10, bottom portion, column Roman 9. Receipt for purchasing prosthetic limb for rupees 10,21,000.
Yes.
But it has not been exhibited. It has only been submitted.
Okay.
It has not been exhibited. That company which has been that artificial limb has been whereupon they purchased, there's no evidence. And what is the lifespan of that prosthetic limb? There is no evidence. Without any evidence, the learned tribunal made an erroneous finding. That is my humble submission before this your lordship. There's no evidence.
The receipt was produced but not proved.
Not proved. Only receipt proved. But veracity of that receipt, only the company has to come and prove that yes, this receipt has been issued by our company, and this is we sold out that prosthetic limb to the victim, and the lifespan of that prosthetic limb is such and such, and after every such and such period, this money has to be spent for re-affix that artificial limb. There is no evidence. Only an erroneous finding.
Okay.
My lord, thereafter, kindly come to my lord. Page 42. Page 42, the assessment portion. Page 42. My lord, second paragraph from bottom. Page 42, the assessment portion, second paragraph from bottom. Therefore, monthly income rupees 31,250 per month. Therefore, for the purpose of calculating damages, multiplication will be 3,75,000. That is into 12 annual income. 40% future prospect has been given. 40% future prospect, but there is no loss of income. There's no loss of income. In fact, the salary has been increased from 31,000 to 38,000. And the work is purely on clerical job. Thereafter, 75% has been 75%. 70% was the permanent disability, the medical certificate. On the basis of that, rupees 62,47,500, the total compensation as arrived. Thereafter, my lord, in the instant case, the claimant has incurred medical expenses of rupees such and such. This amount has been proved. That next, this tribunal is inclined to hold that victim is entitled to receive 5 lakhs towards pain and suffering and rupees 30 lakhs towards future medical expenses. Where is the evidence? Where is the specific finding that 30 lakhs future medical expenses? There's no evidence. Without any evidence, without any specific findings, 30 lakhs has been given. Pain and suffering 5 lakhs. If there is the evidence, well, I can understand, yes, there is a specific evidence that every such and such period, the prosthetic limb has to be changed, and this will be the future medical has to be incurred. Yes, that is all that. But there is no evidence. Without any evidence and without any specific findings, the land tribunal 30 lakhs has been given. And another aspect, my lord, 7% interest has been given.
Okay.
7 you will find at page 43, my lord, 7% interest has been granted. These are all my subject submission before it.
Yes.
Now, my lord, I'll counter what Mr. Pal has submitted issue-wise. First, my lord, I'll not go into the regarding the pay and recovery. That's not for me to defend, my lord. Now, coming to the issue of the pecuniary damages, first is that there is no loss of income, because, my lord, if I lose on that count, my entire award goes. Now, my lord, I'll counter that. My lord, kindly seize the evidence. Kindly comes to, my lord, page 8 of the paper book. Affidavit in chief of Shinchita Ghosh. Paragraph 2.
Yes.
I am a chemical engineer. After completion of the graduation in engineering, I joined in Philips Carbon Black Limited as a trainee engineer in the year on 15th July 2013. On 11th February 2015, my senior colleague Avita Vasu Banerjee was driving the scooty bearing number such and such on which I was a PTN rider. It was around 8:50 a.m. Both we entered inside our factory premises, that is inside Philips Carbon Black Limited at Durgapur, and we are moving towards east by the said scooty along the road inside the factory. By our right side, one oil tanker being number such and such was also moving towards east along the same road inside the factory. It was around 8:50 a.m. Our scooty as well as the involved oil tanker both reached near Old Weybridge inside the factory, and suddenly the said oil tanker being number such and such turns towards its left, and that's at the middle of our scooty. As a result, our scooty fell down towards its left. I fell down on the road and my left leg was run over by the said lorry. My entire left leg was badly smashed. My lord will kindly note the degree of visibility and the kind of injuries. My left leg was badly smashed almost up to my hip joint. Apart from that, the muscles of my right leg above me up to right hip joint was also badly damaged. I was rescued by the people inside the factory and was removed to the Mission Hospital, Durgapur, where I was primarily admitted and was treated up to 13th February 2015. During the tenure of the treatment, my left leg was amputated on 11th February 2015. But as the condition of my wounds and injuries were gradually deteriorating, I was transferred to Woodlands Multi-Speciality Hospital, Kolkata, where I was admitted on 13th February 2015 and was intensively treated there up to 1st May 2015. During the tenure of the treatment, I was operated on 14th February 2015, 16th February 2015, 18th February 2015, 20th February 2015, 21st, 23rd, 25th, 19th March, and 7th April 2015. I was discharged on 1st May 2015 from State Woodlands Hospital. After discharge of the state hospital on 1st May 2015, I was confined into bed at my residence, and intensive treatment is still now continuing under the guidance and supervision of the eminent doctors. I spent more than 43 lakh rupees for treatment of my wounds and injuries, out of which 35 lakh was spent up to the date of filing of the claim case. The offending driver of the involved such and such was moving along the factory road from west towards east direction inside the factory at a very high speed and in a zigzag manner, and when the said offender driver of the oil tanker reached near the old weighbridge of the factory, he suddenly turned his oil tanker towards the left towards the weighbridge and caused the accident. The said offended driver of the oil tanker was solely responsible for the accident. Now alert paragraph 3. That at the time of accident, I was 26 years old. I was engaged in service as an assistant manager, posted at plant office Durgapur of Philips Carbon Black Limited, 27 RN Mukherjee Road, Durgapur, Bardhaman, pin such and such. And head office is at Duncan House, 31 NS Road, Kolkata 1. I joined the concern with a plan to gather some experience, and after completion of training and some experience, I was intending to complete my master's degree in engineering for a better promotion as well as a better job opportunity. Before the accident, I was posted in the factory premises as assistant manager to look after the quality assurance of the products as a chemical engineer. But after the unfortunate accident and physical disability, I cannot perform my duties properly. As a result, my office transferred me to the head office at Kolkata, and now I am engaged in human resource department. My lord will kindly note this one. Practically, I am doing the clerical job only. As an impact, I am suffering from acute job dissatisfaction. Moreover, my service is at the mercy of my superiors. Apart from that, for the accidental injuries and disability, I have lost the alternative job opportunity. At the time of accident, my salary was 31,250 per month, and at present, my salary has been little bit increased. But after the unfortunate accident, as I have lost my left leg, I cannot travel by bus or train and continue my service. I am compelled to travel by a hired vehicle from Batanagar to Dalhousie. So my additional traveling expenses is more than 12,600 per month. Within brackets, my father is staying in a flat situated at Batanagar. For loss of my left leg, I have been compelled to purchase artificial limb. Malad, this is also the argument for that 10,21,000, for which I have been compelled to spend 10,20,000 rupees. The lifespan of the component of the artificial limb is more or less 5 to 6 years, and after every 5 to 6 years, more or less rupees 10 lakh is required to be spent for change of the components. As an impact of the said accidental injuries, I have lost the entire future prospect as a chemical engineer, and my marriage prospect has also been completely ruined. Moreover, I cannot travel even a step without escort. After the unfortunate accident, I am compelled to travel to my office or anywhere with the help of an assistant. I have claimed 1 crore 44 plus medical expenses, cost and interest towards compensation for pecuniary damages as well as non-pecuniary damages. The pecuniary damages are such and non-pecuniary damages are such. Now, my lord will kindly see paragraph 5. There are some entries which have been marked as an exhibits. My lord will kindly see entry number 9, Roman 9, receipt for purchasing prosthetic limb for rupees 10,21,000. Now, my lord, kindly comes to the cross-examination of the victim, which is at page 13 by Reliance General Insurance Company. The accident occurred within factory premises. I cannot say what should be the speed limit of a vehicle within the factory premises. I was a pillion rider of a scooty. I had not personally lodged written complaint with the PS about the accident. My lord, she was in hospital. She was not supposed to. I have not seen the number plate of the offending vehicle at the time of the accident. I did not have any ASI facility at the time. I had group insurance. I had not claimed any compensation from the employer of the factory. The employer of the factory bore the medical expenses for treatment of my injuries at that time, but they deducted the amount from my salary in installment. I cannot submit any document to substantiate my such claim. At the time of accident, I used to earn 31,000 per month. I joined the job on 2/11/2015 after my discharge from the hospital. At present, I earn 38,000 per month. I hold the post of assistant manager, which was the same at the time of accident. The distance between my residence and my workplace is about 20 kilometers. My left leg below knee has been amputated. At present, I am walking by artificial leg. Doctor treating me advised me to the everyday life with assistance of an escort. At present, I cannot move by public vehicle like bus and tram, and I have to take a taxi from my movement. I have claimed in my affidavit in chief that I have paid I have to pay 12,600 per month for that purpose. But I have not submitted any receipt from taxi or from the taxi or bill from the travel company before the court. I can examine witness to prove such and such, my lord, then the general denials are there. My lord, first point is that she was a chemical engineer by profession. She joined the organization in 2013. It has come in evidence.
Yes.
It is uncontroverted. It has come in evidence that she joined as a trainee engineer. Within 2 years, she was promoted as a quality management assistant engineer in the factory premises. Within 2 years, in 2013, she joined. In February 2015, she became a quality engineer, quality check engineer. After the accident, she has been transferred to the human resource department, HR department. She is getting a salary of 38,000, 7,000 rupees increase. That is the Mr. Paul's argument is that 7,000 rupees increase. My lord, we kindly consider this has come in evidence that this is a compassionate appointment depending on the superiors, that it is out of mercy because the accident happened within the factory premises. That's why the employer absorbed her in the job, and only 7,000 has increased from 2015 till the date of evidence. Number one. Number two, my lord, regarding one continuing in the job, whether there is loss of earning capacity, this question has to be answered on the basis of judgments. Now, my lord, I am citing only two judgments, my lord. This is of the Supreme Court. Because this is a very recent judgment, my lord. I have not found the reported version. Here, the case was of a constable who was continuing in service and was getting salary. Supreme Court still decided that it should be decided on the basis of multiplier method. My lord, we kindly see the second paragraph. The appellant has suffered multiple fracture and dislocation of the left elbow, nailing of the right tibia and femur bone. The appellant undergone several surgical procedures, including reconstruction of right elbow. The board of doctors assessed the permanent disability to the extent of 45%. The tribunal, while taking into consideration the emoluments of the appellant as such and such, applied the multiplier of 16, keeping in view of the age of the appellant as 32 years. Thus, the total compensation is such and such was awarded, including the expense towards physiotherapy, special diets, conveyance, loss of earning, towards future medical expenses. 18 lakh was on account of loss of future income due to disability. The High Court, in an appeal filed by the insurance company, reduced the amount of compensation by applying the multiplier of 9 for the reason that there is no loss of employment. We have heard the learned counsel for the parties and find that the High Court has erred in law in reducing the amount of compensation. The appellant, though, continues to be in service, but his efficiency as a constable has been seriously compromised. Therefore, the amount of compensation awarded by the Motor Accident Claims Tribunal as such as 21 lakh was just and proper, keeping in view the injuries and its long-term effect on the person of the appellant. Similar circumstances, getting salary, multiplier was reduced and certain compensation was given by the High Court. That Supreme Court has reversed, saying that this is not a good law. Multiplier has to be applied on the basis of the Sarala Varma, and 21 lakh rupees has been restored. This is by the Honorable Supreme Court. Now, my lord, it is the absolutely similar case. Although my prospect was much higher as a chemical engineer, I could have applied for a job somewhere else. A chemical engineer who had the capability to work in Philips Carbon Black, employment in Philips Carbon Black as a quality engineer. After so many years of service, she is now reduced to a clerical post in the human resource department, and 7,000, my lord, it is my submission, has been increased because of inflation. 31,000 salary could not have continued as 31,000. This is a meager enhancement. Now, my lord, I'll cite another case where the Supreme Court has again held the same, absolutely same point. This case is more appropriate because this is 2014 9 SCC 241. My lord, will kindly come. I'll read. This is Honorable Justice Ramana's judgment. I'll read from the beginning, my lord. The appeal by special leave are directed against the judgment passed by the High Court at Karnataka Circuit Bench at Dharwad in Bajaj Allianz General Insurance Company versus Dinesh Singh. The appellant is the claimant. He filed claim petition being such and such before the Motor Accident Claims Tribunal, HON'BLE, stating that he is a BE degree holder. My lord, it's very similar because here it's also a case of an engineer. BE degree holder in metallurgy. He is aged about 24 years and was working as a quality engineer. My lord, absolutely same facts. In Hospet Steels Limited. On 13th April 2004, while he was returning to his home from the company, he met with an accident. In the accident, he sustained grievous and fracture injuries to the knee and also the left hand. He was taken to a hospital in HON'BLE for treatment where his left leg was amputated. Here also, my lord, left leg amputated. He was in the said hospital as an inpatient till June 2004. Thereafter, he took treatment as Tulsidas Gopalji Charitable and Dhatleshwar Temple Trust and All India Institute of Physiological Medicine and Rehabilitation, Bombay. And he is still under treatment and presently walking with the assistance of an artificial limb. Now, my lord, paragraph 3. According to him, due to the amputation of his left leg, he suffered 100% permanent disability. At the time of accident, he was getting monthly salary of 17,200 as an engineer. Because of the disability, he had to resign as his job as an engineer and take up a desk job in Industrial Development Bank of India. My lord, although here the job was there, he left that quality engineer's job and he joined in a desk job in Industrial Bank of India. Being a bachelor, he has lost prospects of getting married. He thus laid the claim for a total compensation of 40 lakhs under different heads. The respondent resists the claim of the appellant. The tribunal, considering the evidence placed by the appellant, both oral and documentary, awarded in all 30 lakhs as compensation to the appellant under different heads. Against the said award, both appellant as well as the respondent filed appeal before the High Court of Karnataka, the appellant seeking enhancement while the respondent for reduction. Now, my lord, what did the High Court do? The High Court dismissed the appeal filed by the appellant and partly allowed the appeal filed by the respondent and reduced the compensation awarded by the tribunal from 30 lakhs to 6 lakhs. Non-pecuniary damages awarded, my lord.
Yes.
Now, my lord, paragraph 5. The learned counsel for the appellant submitted that the appellant at the time of accident was a young boy of 24 years of age and was unmarried. He completed his engineering in metallurgy and was working in a private company as quality engineer and was getting 17,200 per month. The appellant is very intelligent and because of the amputation of his left leg above the knee, he suffered more than 80% permanent disability and his future became very bleak. The appellant had to resign from his job as an engineer and take up a desk job in a private bank, which he may lose due to recession in the economy. However, the High Court has, without any valid and proper reason, without considering the above facts and without appreciating the evidence properly, has drastically reduced the just and reasonable compensation awarded by the tribunal. He thus prayed that in the facts and circumstances of the case, just and reasonable compensation be granted to the appellant. Now, alert. On the other hand, the learned counsel for the respondent supported the judgment of the High Court as it is reduced the compensation awarded by the tribunal and further contended that the reduced compensation awarded by the High Court is just and reasonable in the facts and circumstances of the case and needs no further enhancement. Heard the learned counsels, appellant and learned counsel for the respondent. Now, my lord, the findings. Paragraph 8. The fact that the appellant suffered injuries in the accident is not in dispute. It is also not in dispute that the appellant is a BE degree holder in metallurgy and was working as a quality engineer in Hospet Steels Limited. Though the appellant contended that at the time of the accident he was earning rupees 17,200 per month, but in the absence of any document produced by the appellant to prove the same, the tribunal as well as the High Court took the monthly salary of the appellant as 12,840 as evidenced by Exhibit P35. And we do not find any error with the said income taken by the tribunal and the High Court. The appellant, due to the injury sustained by him, undisputedly was out of employment for a period of 2 years. However, the High Court committed an error in holding that the appellant was out of employment for 6 months. As the appellant was out of employment for a period of 2 years, his loss of earning for the period would be such and such. The tribunal has rightly awarded. The tribunal, taking into consideration the monthly salary of appellant at rupees 12,000 on considering his young age at 24, applied multiplier 17, and having regard to the 60% permanent disability suffered by him, arrived at the compensation towards future loss of earnings at 15,72,000. However, while agreeing that the appellant was as per Schedule 1 of the Workmen Compensation Act, he suffered 80% permanent disability, taking into consideration the subsequent employment of the appellant in the Industrial Development Bank of India as a grade B officer,
held that the appellant did not suffer any loss of future earnings on account of his permanent disability and accordingly disallowed the claim of the appellant under the head of loss of earnings. We have considered the materials placed before us, particularly the evidence of the doctor who stated that the appellant suffered 60% disability of the total body and in his cross-examination denied the suggestion that the appellant does not require any further treatment. The fact that the appellant has resigned as a quality engineer from Hospet Steels Limited and took up desk job in Industrial Development Bank of India because of his permanent disability suffered by him in the accident is not in dispute. Obviously, because of the permanent disability suffered by the appellant who is an engineer by profession, he cannot take up such profession which requires moving from one place to the other place. My lord will kindly note this. Therefore, the reasoning of the High Court that the appellant has not suffered any financial loss because of permanent disability having regard to the fact that subsequently he took up the employment in Industrial Development Bank of India as a grade B officer cannot be sustained. Once the permanent disability is fixed, taking into consideration its impact on the employment profession of the claimant, the appellant, the compensation has to be awarded. Since the disability suffered by the appellant, which is fixed at 60% and which is permanent in nature, impacted his employment and future prospects, we are of the considered opinion that the tribunal has rightly determined the compensation of 840 into 12 into 17 of 26 lakhs towards loss of future earning, and taking into consideration 60% permanent disability suffered by the appellant, awarded him the actual compensation under the head of loss of earnings of such and such. This is Supreme Court, my lord. Absolutely similar facts and circumstances.
Yes.
Now, my lord, in the judgment, there is a mention of a judgment of the Honorable Supreme Court which has been made the basis of awarding the compensation following the multiplier method. My lord will find that judgment at page 39. My lord will kindly come to page 39. First paragraph, after the figure 3,75,000 rupees, page 39. In this respect, it is proper and just to rely upon the decision of the Honorable Supreme Court of India in the case of Erudhaya Priya versus State Express Transport Corporation Limited. My lord has found that.
Yes.
Erudhaya Priya. This is the judgment which has been relied on. My lord, kindly see that judgment once. My lord kindly comes to paragraph number 4. First page, last paragraph. The respondent state corporation filed an appeal against this order and the appellant filed cross objection. Both of them were decided on the impugned judgment of the High Court dated such and such by a common order. The High Court judgment of the High Court dated such and by a common, the High Court confirming the findings of the negligence of the bus driver reduced the compensation to 25 lakh. Primarily on the ground that the multiplier method for quantifying loss of earning power has been wrongly applied, as it had not come on record as to how the injury suffered by the appellant would have a bearing on her earning capacity as a software engineer. The interest rate was sustained. Now, my lord, this is absolutely similar problem. Software engineer, multiplier method applied, High Court reduced it saying that there is no loss of income. Kindly see the findings, my lord. We have heard the learned counsels for the parties. They have also filed synopses with their respective claims and rebuttals thereof, with the appellant enlisting the principles which can apply for her case and the law being now settled in like cases. My lord, law has now been settled in like cases. My lord kindly comes to paragraph 9. The aforesaid position is not really disputed by the learned counsel for the respondent state corporation, and thus we come to the conclusion that the multiplier to be applied in the case of the appellant has to be 18 and not 17. Loss of earning capacity. B. Loss of earning capacity of the appellant with permanent disability of 31.1%. In respect of the aforesaid, the appellant has claimed compensation on what is stated to be the stated settled principle set out in Jagdish versus Mohan, Sandeep Khanuja versus Atul Dande, we extract below the principles set out in Jagdish case in para 8. In assessing compensation payable, the settled principles need to be borne in mind. A victim who suffers permanent or temporary disability occasioned by an accident is entitled to the award of compensation. The award of compensation must cover, among others, the following aspect: pain, suffering, and trauma resulting from the accident. Then, my lord, it is highlighted. Loss of income, including future income. Highlighted, my lord. The inability of the victim to lead a normal life together with amenities, medical expenses, and loss of expectation of life. The aforesaid principle has also been emphasized in an earlier judgment, that is Sandeep Khanuja case, opining that the multiplier method was logically sound and legally well established to quantify the loss of income and as a result of the death or permanent disability suffered in an accident. In the factual contours of the present case, if we examine the disability certificate, it shows admission, hospitalization on 8 occasions for various number of days over 1.5 years from August to January 2013. The nature of injuries has been set out. I am not reading the nature of injuries, my lord. We have also perused paragraph 13. We have also perused the photographs annexed to the petition showing the current physical state of the appellant. Though it is stated by the learned counsel for the respondent state corporation that the same was not on record in the trial court, be that as it may, this is the position even after treatment and the nature of injuries itself show their extent. Further, it has been opined in para 12 of Sandeep Khanuja case that while applying the multiplier method, future prospects on advancement in life and career are also to be taken into consideration. We are thus unequivocally of the view that there is a merit and contention of the appellant and the aforesaid principles with regard to future prospects must also be applied in the case of the appellant taking the permanent disability as 31.1%. The quantification of the same on the basis of the judgment of National Insurance Company Limited, more specifically in para 59.3, future prospects, my lord, considering the age of the appellant, would be 50% of the actually in the present case. Software engineer reduced, multiplier method applied, disability given, and 50% future prospect also applied. Now, my lord, so with regard to loss of income, this is my argument that, my lord, it is absolutely a fit case which goes on to show that although she was absorbed in the same employment, it was out of mercy. Only 7,000 rupees has been increased, and she has suffered substantial disability of 70%, which disables her from securing an employment as a quality engineer, chemical engineer. Otherwise, it is almost impossible for her to get a job otherwise. Now, my lord, on this particular point, there is the judgments, my lord, there are 3 judgments which I have already cited. Now, this is with regard to the income and loss of earning capacity. Now, second point is the medical expenses, 31 lakh odd, that has been proved, that has been given. Now, 10,20,000 rupees. Now, my lord, kindly comes to the evidence which I have already, I'm not going to read it aloud, my lord. I have already shown at page 10 that has been clearly mentioned, and
Yes.
that document is there. Entry number 9, that has not been exhibited. I admit, my lord. Now, my lord, my argument is that there is also no cross-examination when I state something in the affirmative and I submit documents and the court takes that into consideration and they do not cross-examine that document, then that fact remains uncontroverted. With regard to that, now whether the tribunal can award compensation on the basis of 10,21,000 which has been not been exhibited and where the author has not come and proved those documents, whether that award can be given or not, that is the only question. That also, my lord, I'll answer with 2 judgments, one of the Supreme Court and one of our High Court.
No, it was 30 lakh.
No,
Future,
my lord,
future
30
medical
lakh,
expense.
30 lakh future medical expenses. But I am breaking that 30 lakh, 10,21,000 rupees first, which is incurred for the prosthetic limb.
Prosthetic limb.
Because 30 lakhs, out of those 30 lakhs, my lord, the majority will be for the prosthetic limb.
Yes.
Now, my lord, I am relying on, this is a very old judgment, 2013 8 SCC 389, Rekha Jain versus National Insurance Company. My lord, this particular case is actually, we rely on this case to show that in a case of 30% permanent disability, 100% functional disability can be given. But,
Yes.
my lord, this case also points out several important factors. My lord will kindly, this is a case, my lord, this is here, she was an actor and there was some facial disfigurement. Supreme Court held that although she is medically 30% unfit or 30% disabled, because she is an actor, then it is 100% disability. This is the main ratio. Now, my lord, another ratio is there, kindly comes to paragraph number 19 of this judgment. Page 403, my lord. Now, 17 lakh medical expenses was given in this case. The High Court reduced it to 7 lakh, saying that there is no documentary evidence. My lord, kindly sees paragraph 18.2.
Yes.
Whether the tribunal, this is the question framed by the Supreme Court, whether the tribunal is justified in awarding rupees 17 lakhs and award towards pecuniary damages, my lord, not pecuniary damages in favor of the appellant, namely medical charges, medicine expenses and other expenses on the basis of documentary evidence on record. Now, my lord, kindly see paragraph 20. The High Court has gravely erred both on facts and in law in interfering with the impugned judgment and award of the tribunal in reducing the pecuniary damages awarded towards medical expenses incurred by the appellant herein from 17 lakhs to 7 lakh. Solely on the ground that there is no documentary evidence in relation to the amount spent towards medical expenses, which is awarded by the tribunal. This assumption by the learned judge of the High Court is factually not correct. As could be seen from the record, there are large number of medical bills and vouchers produced by the appellant for having spent the money towards the surgeries conducted upon her and payment made to various hospitals and nursing homes, namely VSS Medical Hospital, Burla, Kalinga Hospital, Bhubaneswar, Nursing Home, Cuttack, along with purchase of medicines of the aforesaid period, which run to rupees 17,51,726. The aforesaid factual aspects are stated in unequivocal terms in her statement of evidence. And she has also referred to the documents such as bills, receipts, and vouchers obtained by her from various medical stores on the basis of the prescriptions of the doctors who have treated her. Some of the documents were marked in the evidence of PW3. Some of the documents were marked in the evidence of PW3. The appellant herein and she had spoken about the expenses incurred toward her treatment and purchase of medicines. In relation to some other documents, the learned counsel for the insurance company has objected for making them exhibits without raising tenable objections. The learned member of the tribunal neither upheld nor rejected the objection raised by the counsel on behalf of the respondent insurance company at the time of marking documents through the appellant in her evidence. Nonetheless, the learned member of the tribunal has taken those documents into consideration and has awarded compensation under pecuniary damages, having regard to the clinching evidence on record that the surgeries were conducted and treatment was taken by her in various hospitals and nursing homes for a period of 4 years. The correctness of the said claim is examined by us with reference to the documents. Annexure P7 produced in this case, in which date-wise particulars with regard to the name of the institution and medical stores, the expenses incurred and the bill numbers, payment made for the purpose of conducting blood tests, purchase of medicines, purchase of blood from the blood bank and cost of surgery spent in the appellant are given. The tribunal, in the absence of rebuttal evidence and the nature of cross-examination of the appellant, PW3, made by the learned counsel on behalf of the insurance company and the evidence adduced by the appellant herein, and the claim made by her under the pecuniary damages towards the medical expenses, tests, surgeries, etc., and other incidental purposes, has accepted and has rightly awarded a sum of rupees 17,51,726 under the heading of medical expenses. The same has been arbitrarily and unreasonably, without assigning any cogent and valid reason, interfered with by the High Court, and it has erroneously modified the judgment by reducing the amount of 17 lakh to 7 lakhs. This has been lightly interfered with by the learned judge of the High Court without application of mind and consideration of legal evidence on record, particularly in the absence of rebuttal evidence. And further, the insurance company was unable to show that the documents referred to supra produced by the appellant in her evidence were fabricated documents, which have been produced with deliberate intention to prefer a false claim in this regard, as contended by the learned counsel on behalf of the insurance company. We have carefully examined the evidence on record and the findings of the tribunal to examine as to whether the findings recorded by the High Court in the impugned judgment for reduction of pecuniary damages from 17 to 7 are correct. On careful perusal of the evidence and documents produced by the appellant, we have to hold that the finding and reason recorded by the High Court is wholly erroneous in law, as the same is contrary to the facts pleaded and proved by producing evidence on record. Therefore, the same is required to be interfered with by this court in these appeals. According point 1 and 2 are answered in the affirmative in favor of the appellant. Rebuttal evidence was not there, my lord, in this case. Cross-examination was not there. 10,21,000 with maintenance, everything is there in the bill, and LCR is before your lordship. My lord can kindly check that 10,21,000 bill, which is a part of the LCR. And these are the judgments, my lord, which clearly says that even though that document has not been proved, the court can take judicial discretion, can apply judicial discretion and take these documents on record and award a relief. My lord, on this particular point, there is another judgment of our High Court which I will cite. This here also, my lord, the documents argued by Mr. Pahadi and Mr. Bonik, my lord, will kindly come to the second page. Second page, my lord, third paragraph. This is Dodul Paul versus United India. Third paragraph. The appellant before us, second page, third paragraph. The appellant before us met with an accident on February 3, 2000. She was initially admitted to a hospital at Asansol and thereafter taken to a nursing home at Asansol, ultimately to be treated at Kolkata. The treatment at Kolkata spanned over several visits by the appellant. The appellant claims compensation for medical expenses incurred by her in such treatment. She had adduced evidence in support of the medical expenses incurred by her before the tribunal. We have considered the evidence toward medical expenses produced by the appellant. It was not suggested before us by the respondent number 1 that the medical expenses incurred by her were not towards the treatment of the appellant consequent to the accident. The tribunal did not allow the claim on the ground that the appellant did not examine the persons who had issued the bills of medical expenses. Exactly Mr. Paul's argument. The bills issued by the nursing home at Kolkata did not give any reason about the receipt of the money of the appellant. We have considered the receipts issued by the nursing home at Kolkata. These are receipts issued by the nursing home. The original receipts were produced in evidence. The bills and receipt for the medical expenses were also produced in original by the appellant. The appellant came into possession of such original bills and received in course of her treatment. These, according to us, my lord will kindly note this, these, according to us, are sufficient evidence of the appellant incurring the quantum of the medical expenses as would appear on the bills and receipts. It would be harsh and in fact unjust for the tribunal to require an applicant witness before it to establish the veracity or otherwise of such bills and receipts. My lord will kindly come to next paragraph. In such circumstances, we are of the view that the appellant has adequately established her claim for reimbursement of medical expenses for treatment for a sum of rupees 2,69,000. Original medical bills were on record. It is being said that these are sufficient. Now, my lord, kindly appreciate the evidence in its totality. 31 lakh rupees, 34 lakh rupees odd spent. It could not have been a case that I could have spent 34 lakh rupees and I could have proved those, I have proved those documents. I could not prove 10,21,000. 10,21,000 bills were issued. My lord can see the record. Summons were issued. They did not come. That's not the fault of the claimant, my lord. And there are judgments which says that these can be taken into consideration, and the honorable tribunal has done so. Now, my lord, 30 lakh rupees non-pecuniary damages. My lord will kindly see the disability certificate once, which is at page 63. This is the details. My lord will kindly come to page 64, following paragraph, following page 64. entry number C, he or she was 70% permanent physical impairment left in relation to her left lower limb part of body as per guidelines to be specified. The applicant has submitted the following documents: ration card, voter card. My lord will kindly see, she cannot travel without assistance of an escort. After the table. Now my lord kindly comes to 135. This is another medical certificate issued by the
135.
my lord 135. 135. My lord will kindly see, this also says 70%. She cannot, in the bold letters in the middle position of the certificate, it is
Page 63 issued by the
my lord,
issued
page
by the
63 is issued by the Medical College and Hospital, Office of the Superintendent come Vice Principal,
medical.
College and Hospital. And this one, my lord will kindly see, this was also issued by, but this was signed by the signature of the government doctor. She is the Medical Superintendent come Vice Principal. My lord,
Yes.
this was issued by the treating doctor. My lord, we kindly see that at page 63, there's the sign, there's the signature and stamp of prosthetist and orthotist, Commissioner Disabilities, Government of West Bengal. This certificate was issued was prosthetist and orthotist, Commissioner Disabilities, Government of West Bengal. And this document is also comes under medical college. And at page 135, this was issued by the superintendent herself. My lord, will kindly see at middle portion of page 135 in capital letters, block letters, it has been written, she cannot travel without the assistance of an escort, orthopedically paraplegic person, patients. She cannot travel with an assistance of an escort, who cannot travel with an escort, completely blind, totally deaf and dumb person. So, my lord, this is written in capital letters. And at the subsequent page, now my lord, kindly comes to the evidence of the doctor. What is the injury? Yes. My lord, kindly comes to page 16, 16. At present, 16, my lord. The doctor.
Okay.
At present, I am Assistant Professor, Department of Orthopedics, Medical College and Hospital, Kolkata. I came to depose in this case as authorized by Medical Superintendent come Vice Principal, Medical College and Hospital, Kolkata. This is the authorization letter dated such and such. On 26/10/2016, I examined one Shinchita Ghosh and issued disability certificate. This is the disability certificate issued by me, already marked as Exhibit 5. In my opinion, the extent of disability suffered by the patient is 70% due to left lower limb amputation below knee. The disability is permanent in nature and it is residual disability under the schedule injury. On the basis of the disability certificate issued by me, another disability certificate was issued by Medical Superintendent come Vice Principal, Medical College and Hospital, Kolkata. I know her handwriting and signature in course of official work. This is the attested copy of the said disability certificate issued by Professor Dr. Shikha Banerjee, Medical Superintendent come Vice Principal, Medical College and Hospital, Kolkata. Original shown and returned. Marked as Exhibit 13. I issued the disability certificate on the basis of assessment and certification of disability, permanent physical impairment rules and guidelines in respect of lower limb. Cross-examination of the insurance company. My lord, this doctor was the best person to examine that whether 70% disability resulted in any functional disability or not. My lord, kindly sees the cross-examination. I issued the disability certificate as part of medical board. As this case is a lower limb amputation, I was there for the orthopedic side. I identified the patient in person and examined her. She was present all along before the board. As per the norms of Medical College and Hospital, 2 disability certificate in respect of disability of 1 patient was issued. One by myself as orthopedic doctor and another by the Medical Superintendent come Vice Principal, Medical College and Hospital. We have not treated the patient, not a fact that I had issued the certificate being biased. So, my lord, I have substantiated my case that I suffered 70% permanent disability. I suffered more than that functional disability. The doctor who said that she suffered 70% functional permanent disability, whether that could have resulted in functional disability or not, if that argument is raised, they should have cross-examined the doctor who issued that disability certificate. Now, my lord, kindly also comes to the kind for non-pecuniary damages. It has been argued by Mr. Paul, my lord, that 5 lakh rupees pain and suffering has been given. My lord, kindly once comes to page number my lord, kindly comes to page 96 once. Page 96. My lord, there is a column called theatre fees. Page 96. This is the bill of Woodlands Hospital. Page 96.
Yes.
My lord, will kindly see there is an entry called theatre fees.
Yes.
My lord, these are the OT charges. Kindly see how many surgeries she has undergone. Reconstructive surgery on 14th February, 16th February, 18th February, 21st February, 23rd February, 25th February, 27th February, 2nd March, 4th March, 6th March, 9th March, 12th March, 14th March, 17th March, 20th March, 23rd March, 25th March, 28th March, 31st March, 4th March, 4th April, 7th April, 10th April, 14th April, 17th April, 20th April, 22nd April, 27th April. These are the reconstructive surgeries she has undergone. Now, my lord, she was admitted. The accident occurred on 11th February 2015.
Yes.
Her leg was amputated on 11th February 2015 itself. She was in Mercy Hospital on 13th February 2015. And after that, from 13th February till the month of May, for 3 months, she was admitted in the hospital. Overall, 80 days of hospitalization. And 27 surgeries, my lord. 27 surgeries. Proved by documents, marked as exhibits, cross-examined, not disputed. 27 surgeries, my lord. And what exactly was her injury at the time of occurrence of the incident? My lord, will kindly see the discharge certificate or the risk bond certificate issued by Mission Hospital at Durgapur. Kindly comes to page 140, my lord. My lord has come to 140. My lord,
Yes.
she suffered degloving injury over left leg with complete exposure of long bones and both bones of LL anatomical structure, fascia and adipose fascia were exposed. Wound was contaminated. Left hand, deep lacerated wound present measuring approx 4 inch by 1 inch. Wound present was contaminated. Radial pulse present. CRT 3 seconds. Femoral presence. Digits agonized. Needle predicted. No bleeding present. Cold, calm. This was her condition at the time of admission. Lacerated injury, exposed bones, anatomical structure of the fascia exposed, wound was contaminated, right hand was contaminated. This is exhibited document. The evidence of the Mercy Hospital is also on record. He has not been cross-examined on the grounds of veracity of these claims. So, my lord, to conclude, my lord, I'll only say one thing, that although it has been claimed that there's no loss of income, there is a loss of huge future income which was possible. She is limited to 38,000 rupees. After so many years of service, she has got 7,000 rupees increment. She is working in a completely different, what is the job of an engineer, that also a chemical engineer in a HR department, in a clerical post. Her future prospect has been restricted. I have shown judgments, my lord, which goes on to show that although the job was there, the Supreme Court has applied the multiplier method time and again and has awarded compensation. I humbly request, my lord, will kindly apply the multiplier method by taking the income of 31,000, which has been done by the tribunal. Future, my lord, loss of the disability, functional disability is 100%, but I'll leave it to your lordship. 70% is what has been proved. My lord, third point is that transportation charges, as per RD Hattangadi, transportation charges, there's specific proof that I spent 12,600 rupees, has to be awarded. Attendant charges has to be awarded because there's proof. The disability certificates say that she requires an escort. She, in her evidence, states that I need an escort. Without escort, I cannot move. That has not been cross-examined. She says in her evidence, I spent 12,600 rupees to go to my residence because I cannot take a tram or a bus. That has not been controverted. So transportation charges should be awarded. My lord, future medical expenses, my lord, in these kind of cases, lot of future medical expenses, it's on a recurring basis. My lord can see the document where 10,21,000. She is walking with a prosthetic leg, that has also come in evidence. She is saying that I walk with a prosthetic leg. It's nothing to hide. And that prosthetic leg, my lord, from time to time has to be replaced, components has to be replaced. 10,21,000 she has already spent. That bill is there. I have shown documents, judgments, my lord, where these documents are taken into consideration without even formal proof, because this is a beneficial legislation and this is a inquisitorial jurisdiction. And third, my lord, 30 lakh rupees which has been given is appropriate. I have shown the injuries. I have shown 27 surgeries in 80 days. Proved documents. Pain and suffering 5 lakh rupees is meager, my lord. My lord will kindly see the judgments which the Honorable Supreme Court has passed in these kind of injuries where severe facial disfigurement and amputation of left leg is there. 5 lakh rupees is not a huge amount. And moreover, my lord, one last point, marriage prospects has been completely destroyed. She is still unmarried. She is not married. So marriage prospects, she has to be compensated. Supreme Court and time and again has in different cases awarded loss of marriage prospects. This is a fit case, my lord, where marriage prospects should be awarded. Because specifically, it is there in the evidence and not cross-examined on that point.
Yes.
That's all, my lord.
My lord, I'm sorry, my lord. I missed, my lord, one vital point. My lord, my lord, I invite Mr. Mondal to reply on this issue. My lord, employer, page 20. Page 20. Page 20. My lord, page 20, my lord, second paragraph.
PW5.
Division of employer. Second paragraph. I have bought system generated copy of Form 16 for the year 2014 to 15. Now kindly come to my lord, Form 16. Form 16 is at page 179. Page 179. My lord, date of accident is, my lord, that is on, my lord, 11th February. Date of accident is, my lord, 11th February 2015. Date of
Yes.
accident. And my lord, kindly come to page 179. This is the, my lord, Form 16 issued by the employer.
170.
179. Form 16 issued by the employer and my lord, exhibited by the employer also.
Yes.
My lord, you will find from my lord, Form 16 is prepared from 1st April 2014 to 31st March 2015. You should got it, my lord? And total income for this in this period, my lord, just before accident, total income was rupees 2,32,403. No tax was deducted. That was her annual income before accident. And Lane Tribunal, my lord, assessed annual income rupees, my lord, 3 lakh something, my lord. That is, my lord, 3,75,000. In fact, learned tribunal assessed 31,250 monthly income. 31,250 monthly income. Next page, your lordship will find from page 181. Your lordship will find the last 12 months salary slip. April 2014, 19,250 gross total income. Next page. May 2014, 19,250. June 2014, 19,215. July 2014, 34,250. Next, August 2014, 28,153. September 2014, 25,000. Again, October 2014, 25,000. November 2014, 25,000. Next month, December 2014, 23,750. January, just before accident, January 2014, June 2015, 23,750 gross total income. In February, when the accident occurred, February 2015, 11th February 2015, accident occurred. In the month of February, the salary was 23,750. That monthly income assessed erroneously.
Okay, monthly income assessed erroneously.
Erroneously. Because Form 16 is the best document. Form 16 is the best document. When Form 16 is submitted by the employer, whereby that gross total income comes to rupees 2,32,403, and Nalin Tribunal assessed 3,75,000 on the basis of only oral evidence. There is no document that before accident the monthly income was 31,250. There's no, because last salary slips were produced. Form 16 for the relevant period filed. Last 12 months salary slips were filed, but 31 to 50, there is no evidence.
Yes.
Another aspect, Mr. Mondol submitted that page 135 is the certificate issued by the treating doctor. No.
No, not treating doctor.
Not
Someone
okay.
who issued the
You have said
disability
that they are
certificate.
treating doctor.
No,
No, not
disability
treating doctor.
certificate.
They disability, only disability,
Yes.
not treating doctor.
Yes.
Not treating doctor. Only disability.
Disability. I
Only
agree to that.
disability.
Yes, PW3, the doctor said that he has not stated that.
Yes,
Yes,
I
yes,
said.
he
I'm not saying that
Yes,
he
not
treated.
treating doctor.
I'm saying that he issued the disability
Yes,
certificate.
only issued disability certificate.
Yes.
She was examined and treated and given certificate 70%.
Yes.
Therefore, that Malandra has submitted that there was no cross examination regarding functional disability, because there was no scope to cross examine that person, because he was not the treating doctor. If the treating doctor was there is a scope that what was the actual position of the patient, because only the patient himself produced them before the appeared before the medical board, and after examination and physically and or clinically issued only 70% certificate. There's no scope to cross-examine that person, that doctor, that kindly appraises what would be the functional disability of the victim. There's no scope, because the treating doctor was not produced before the learned tribunal. It is the discretion of the court to assess functional disability by considering the nature of job,
Yes.
by considering the nature of injury. As Rajkumar and Anjay Kumar, as the ratio has been decided. in Rajkumar Ajay Kumar's, that Honorable Apex Court says, in every case, the handicap certificate doesn't mean that that would be the functional disability. Functional disability would depend upon the nature of job, the age of the victim, nature of injury. That is the main criteria to
Yes.
assess functional disability.
Anything?
No, Malad, this is not Malad.
So, Malad, regarding income,
Yes.
Malad, only two small, very small submissions, Malad. First, with regard to the functional disability, Malad, we have adduced the documents. We have adduced those documents in evidence. Uh, the name of the doctors, treating doctors. We have proved our permanent disability, residual disability by way of disability certificate. The treating doctors, now Malad, the functional disability part that they doubt, because 70% the court has accepted. They doubted that. The treating doctors, the name of the treating doctors in the Woodlands as well as in Mercy Hospital were before them. If they wanted to prove that no, functional disability is lesser, they could have summoned them. They did not prove their case. Why should I bring doctors to prove, no, I did not suffer functional disability? It was their job, because we established that 70% functional disability or more was there. So this is my response, my lord, to that functional disability. Regarding income, my lord will kindly see there are two documents. One is at Exhibit 18 and Exhibit 19 with regard to the income. I
Page-
agree, my lord, what Mr. Paul,
Page
page 179.
179.
Yes,
That is the form 16. Okay.
yes, Form 16. Now, my lord, I agree with Mr. Paul what he said, that Form 16 says this is for the period of April to March.
Yes.
Now, my lord, there will be a lesser amount, 2,32,403. My lord will kindly see that these are the already submitted.
Yes.
So, my lord, after that, why there is a lesser amount? My lord will kindly see in the at page 190. This is the last pay slip of Carbon Black Limited.
190.
190.
For
I
the
agree,
month
my
of
lord.
January.
In the month of January. The accident was in the month of February. I agree. I agree with Mr. Paul what he said, that 31,750 I have also not found. The court held in my claim application, my lord, I have claimed the income was 31,250.
Yes.
But the employee of Philips Carbon Black Limited came and they adduced an evidence that these are the pay slips. Last pay slip is of January.
February also.
February also, but February is
Okay.
the month of the accident. So January is the last pay slip. My lord will kindly see the figure is 23,750. From
Page
that,
190.
page 190. From that, my lord, one deduction is to be there. The professional tax has to be deducted, 130.
Yes.
So my lord, that can be, my lord, adjusted at 23,750 minus the professional tax. That should be the. But my lord, I'm saying this, but my lord will kindly not record that I have said this. But on
Yes.
record, I can't improve on the brief, because that is what the documents.
Very well. Very. Yes. Okay, hard. The instant appeal has been preferred against the judgment and award dated 28 March 2022, passed by the learned judge, motor accident.
I'm sorry, just a minute. Just your lordship asked me that whether the oil tanker is a hazardous goods or not. I just make a search towards Google. Wherefrom I find the list of hazardous goods. Wherefrom I find that in flammable class 3 flammable liquids. These are the hazardous goods.
There must have some notification like that.
Yes, classification. I'm searching.
Yes. learned judge, motor accident claim tribunal, ADJ, 7th FTC, Alipur, 24 Parganas, in MSC case number 726 of 2015. Full stop. The brief fact of the case is that the injured of this case, namely Sinchita Ghosh, on 11/2/2015, being a pillion rider with her senior colleague, entered inside the plant office complex of Philips Carbon Black Limited at Durgapur, and moving towards east by their scooty along the road inside the factory. Full stop. At the time, one oil tanker being numbered WB 37B hyphen 4101 was also moving towards the east with very high speed. Full stop. When both the vehicles reached near the old way bridge inside the factory, suddenly the said oil tanker turned towards its left side and dashed the scooty. As a result, the scooty fell down towards its left side, and the victim was also fell down on the road. At the time, the left leg of the victim was run over by the said tanker, causing severe injury all over her body. Mainly, the victim's left leg was badly smashed, almost up to hip joint, including the muscles of right leg above knee up to the right hip joint was also badly damaged. Stop. Thereafter, the victim was rescued by the people inside the factory and admitted to the Mission Hospital, Durgapur, where she was admitted and treated up to 13/12/2015. Her left leg was amputated on 11/2/2015. Full stop. Subsequently, the victim was transferred and admitted to the Woodland Multispecialty Hospital, Kolkata, on 13/2/2015, wherein after intensive treatment and operation, the victim was discharged on 1/5/2015 from the hospital. The injured filed a claim case before the learned tribunal for getting compensation. The next part, the injured, on the ground that the accident happened only due to rash and negligent driving of the driver of the offending vehicle within bracket oil tanker. The claim case was contested by the insurance company by filing written statement. Stop. After hearing the parties and after receiving the evidences, the learned tribunal has awarded a sum of rupees 1,28,96,237 together with 7% interest per annum from the date of filing of the claim application towards the compensation of this case, and directed the insurance company to pay the compensation. Stop. Being agreed by and dissatisfied with the said compensation, said award, the instant appeal has been preferred by the insurance company. Full stop. The claimant also preferred one cross appeal against the said order being caught 81 of 2022. Stop. Both the appeal and the cross appeal are taken up for hearing for uniformity of the decisions. Full stop. The learned advocate for the appellant, Mr. Paul, submits that basically the appeal has been preferred only two grounds. Firstly, the learned tribunal has opined in the body of the impugned judgment and award that though the driver of the offending vehicle had no valid driving license to drive the oil tanker, but the insurance company may be liable to pay the compensation to the third party, and thereafter they may be given an liberty to recover the same from the owner of the offending vehicle. Full stop. Mr. Paul submits that the said observation was not culminated to any specific direction at the operative portion of the judgment. The operative portion of the judgment. She argued that the
central motor vehicles, I give it a flag marking, my lord. List of hazards, last
petroleum crude oil.
petroleum crude oil. First flag mark, kindly come to the first flag mark.
List of hazardous.
List of hazards. 137. Rule 137, list of hazardous goods. These are the table, and petroleum crude oil is the hazardous goods.
Under Rule 137.
Under Rule 137 and Table 2.
Yes. Argued that during the evidence, the insurance company has called the motor vehicle inspector of Purbo Bardhaman to verify the driving license of the driver of the offending vehicle. Stop. The DW1 has stated that the driving license of the driver was issued on 27/11/2001 for driving LMV, motorcycle, transport vehicle, etc. He further stated that the new driving license for driving transport vehicle was issued on 27/11/2001 up to 18/6/2020 from MV Authority Bardhaman. Stop. The PW2 is the assistant manager of East Zone of Reliance General Insurance Company Limited, who deposed that the driver had valid driving license to drive LMV capital within bracket NT, comma MCWG, comma trans TRANS within bracket LTV plus MGV plus HGV bracket close, driving license valid from 15/6/2020 to 14/6/2025. Mr. Paul further submits that the oil tanker, the oil, that is the petroleum, the oil, sorry, the relevant oil tanker was carrying the petroleum crude oil, which is covered under the Rule 137 in motor vehicle, in Central Motor Vehicle Rule 1989. Full stop. According to the schedule of Rule 137, the petroleum crude oil come under the nature of hazardous, nature of dangerous or hazardous good, as specified in column number 2. Stop. I have perused the rule, including the Central Motor Vehicles rules. I have perused the Central Motor Vehicles Rule 137 of Central Motor Vehicles rules and schedule thereof. In the said schedule, the entry number 1656 is the petroleum crude oil, which termed as the dangerous and hazardous goods. Thus, considering the entire fact, it appears to me that the argument advanced on behalf of the insurance company is justified. Full stop. The driver of the offending vehicle may have valid driving license at the time of alleged accident, that is on 11th February 2015, comma, but he did not have the driving license. He did not have that license to drive the vehicle carrying the nature of goods which are dangerous and hazardous. Stop. On such way, the owner of the offending vehicle must have violated the terms of the policy valid with the insurance company at the day of accident. Thus, in my view, the insurance company is entitled to get the relief as observed by the learned tribunal in the body of the judgment. Full stop. This issue decided in favor of the insurance company. Happy, right? Stop. Next para. Secondly, underline. Secondly, the secondly, Mr. Paul submits that the quantum of compensation as awarded by the learned tribunal is erroneous on several grounds. Firstly, the firstly, the learned tribunal has adopted the monthly income of the injured to be rupees 31,250 per month. There are no such evidence or documentary proof regarding such monthly income of the injured. Moreover, the employer of the injured has appeared before the learned tribunal and exhibited the Form 16 issued by the employer in favor of the injured, including the pay slips. The last pay slips for the month of January 2015 was also exhibited, wherefrom it appears that the gross total earning of the injured was 23,750. So the monthly income adopted by the learned tribunal on the basis of the claim application is erroneous. Next part. Mr. Paul further argued that the learned tribunal has awarded 40% future prospects, which was added with the income of the deceased. He submits that the injured has deposed before the learned tribunal as PW1, full stop. In her cross-examination, he admitted that at the time of accident, he used to earn rupees 31,000 per month, and at present, his earning was 38,000. Stop. There are no loss of income of the injured due to such accident. Rather, her income was increased. So, the future prospects considered by the learned tribunal is erroneous. Full stop. Mr. Paul further argued that there is no loss of income in this case. So the injured can only entitled to get the non-pecuniary damages, pecuniary and non-pecuniary damages. Next one. Mr. Paul further argued that the learned tribunal has considered the disability of the injured to be 70%, and thus permanent disability was calculated and the award was given. From the attending facts and circumstances, the percentage of disability as assessed by the learned tribunal is not proper. Full stop. Lastly, Mr. Paul submits that the learned tribunal has awarded 5 lakhs towards the pain and suffering, and also awarded rupees 30 lakhs towards the future medical expenses, including the replacement of component of artificial limb and also future transportation charge in addition to other compensation. Mr. Paul submits that the awarding future medical expenses of huge amount of rupees 30 lakh is not justified. Stop. There is no specific evidence of cost of prosthetic limb and its requirement for replacement of components after a few years. Stop. Mr. Paul frankly submits that though the PW1 stroke injured has produced the receipt for purchasing prosthetic limb before the learned tribunal, but such receipt was not validly proved. So he argued that the learned tribunal has erroneously awarded the compensation of future medical expenses. Full stop. Mr. Paul further argued that in this case, an interest of 7% per annum was awarded by the learned tribunal, which is in the higher side. Full stop. Next paragraph. Mr. Mondal, appearing on behalf of the claimant, submits that the argument advanced by Mr. Paul is not justified. Full stop. He submits that the income of the injured was specifically proved by calling the employer who deposed before this learned tribunal and has produced the pay slips. From the pay slips, it would be revealed that just before the accident, the injured has received the monthly salary of rupees 23,750, wherefrom the professional tax of rupees 130 can be deducted. Full stop. Next paragraph. Mr. Mondal submits that this is a fit case where the earning prospects of the injured has been totally disrupted by the said accident. Stop. He submits that the injured was an young lady aged about 26 years old, young unmarried lady, aged about 26 years old, and was engaged in a service as assistant manager posted at plant office Durgapur of Philips Carbon Black Limited. Her prospects was to gain some experience in such factory and thereafter intend to complete master degree in engineering for better promotion as well as to obtain better job opportunity. Just few days of his service, he promoted to the post of factory premises as assistant manager to look after the quality assurance of the products as a chemical engineer. Stop. His career was going smoothly and upwardsly. But due to such accident, his entire profile and entire prospects of job has been drastically changed. Mr. Mondal further argued that as the accident happened within the factory premises, so the owner had showed mercy upon the injured, and he was engaged in a separate job and compelled to employed as HRD department, that is a desk work at the head office of Kolkata. Full stop. Mr. Mondal further submits that the increase of his salary is due to the inflation, but his entire job prospects of chemical engineer has been entirely lost. So in this case, the claimant has suffered huge loss of income. Stop. In support of his contention, Mr. Mondal has cited two decisions of Honorable Apex Court passed in Hari Om Constable versus National Insurance Company Limited, within bracket civil appeal number 7262 of 2022, bracket closed, as well, and Dinesh Singh versus Bajaj Allianz Insurance Company Limited, reported in within bracket 2014 9 SCC 241. Stop. Mr. Mondal argued that in a case of Horiom Supra, a constable has suffered multiple fracture injury and dislocation of elbow and other bodily infirmity, wherein the doctor has assessed the permanent disability of 45%. The tribunal has awarded a compensation applying the multiplier of 16, wherein the Honorable High Court has reduced the multiplier of 9, considering the fact that her job was not lost, but the Honorable Apex Court has supported the view of the Planet Tribunal with a finding that the continuous to be in service of the constable cannot be considered, as his efficiency as a constable has been seriously compromised by the accident. Stop. In Dinesh Singh Supra, the Honorable Apex Court, in the similar facts and circumstances, has adopted the correct multiplier and set aside the order passed by the Honorable High Court, wherein the compensation was reduced. Mr. Mondal further argued that in this case, the learned tribunal has correctly adopted the multiplier and also has considered the permanent disability to be 70%. Stop. He argued that in this case, the injured was a chemical engineer. Due to such accident, his prospects as a chemical engineer has been lost, and she was only engaged in a desk job. So in this case, the claimant is entitled to get the 100% disability towards his occupation functional disability, towards her functional disability. Stop. Next paragraph. Mr. Mondal further argued that the learned tribunal has awarded 5 lakh towards the pain and suffering and further 30 lakh towards the future medical expenses. Stop. The award passed by the learned tribunal is not excessive. Full stop. The case of the accident goes to show that on the day of accident, that is on 11/2/2015, the injured was admitted to the Mission Hospital, Durgapur, wherein her leg was amputated. Her left leg was amputated. Thereafter, on 13/2/2015, he was shifted to the Woodlands Multi-Speciality Hospital, Kolkata, wherein he was admitted till 13/2 admitted from 13/2/2015 to 1/5/2015. Stop. During her treatment at the Woodland Hospital, there are at least 27 surgeries at her person, and about more than 80 days she was hospitalized. The injured has suffered immense pain during the treatment and operation. Such pain she could not be suffered if the accident had not happened. She further argued that the amount of compensation of rupees 5 lakh was the pain and suffering in this case is meager one. Full stop. Next part. Mr. Mondal further argued that the rupees 30 lakh was awarded towards the future medical expenses, including the cost of prosthetic limb and replacement of components of prosthetic limb. Full stop. It is true that the bill of prosthetic limb of rupees 10 lakh 21,000 was 20,000, though produced before the learned tribunal, but it was not sufficiently proved. Stop. The injured has issued summon upon the competent person to for proving the same document, but none appeared after receiving the summons. Stop. The learned tribunal has considered the receipt which was produced before him and also considered the evidence as advanced by the injured as PW1. After considering the entire facts, the learned tribunal has correctly awarded rupees 30 lakh. Full stop. he submits that and that the honorable division bench of this court as well as the honorable apex court has held that though the documents are not proved, but if they are placed in the record, they can be considered to provide just and proper compensation. In support of his contention, he cited Rekha Jain versus National Insurance Company Limited within bracket 2013, 8 SCC 389, and Dodul Pal versus United India Insurance Company Limited, reported in 2015, SCC Online 496. Are the learned next? Are the learned advocates peruse the materials, including the exhibits placed in the informal paper book as well as the exhibits in the LCR. It appears that the PW5 is one of the employer of the PW5 which appeared on behalf of the employer of the injured and exhibited the payslip as well as the Form 16 issued by the said organization in favor of the injured. Stop. It appears that just before the accident, the payslip for the month of January 2015 stated the gross income of the injured was 23,750. It appears from the deduction column that the professional tax of rupees 130 was deducted. So, considering the payslip of for the month of January 2015,
23,620.
the monthly income of the injured just before the accident was 23,620.
Yes.
6,000.
23620.
23620. Full stop. Next one. It is argued before this court by the insurance company that the injured, that is the claimant, is not entitled for any compensation towards the loss of income. Stop. On plain perusal of the instant fact of accident, it appears to me that the entire job opportunity of the present claimant has been destroyed due to such accident. Stop. She was a chemical engineer and has just started his job as a junior engineer in a factory. At the time, she suffered the accident. Stop. Due to such accident, her left leg was amputated and she is now suffering as a limping person with the help of prosthetic limb. Full stop. it is admitted fact that after such accident, he was engaged by the employer in a completely separate job, wherein his expertise towards the chemical engineering was not involved. Stop. If the accident had not happened, the injured may have entered in a further higher degree, and she may have got some job which is more lucrative and more incomeable than the job which she is now performing in a table work under the department of HRD of the said concern. Stop. Considering the fact, it appears to me that the present it appears to me that due to such accident, the present injured claimant has lost his entire prospects of job opportunity. Thus, she is entitled to the compensation towards the loss of income. Stop. Next one. In considering the disability certificate issued by the doctors who deposed as the PW3 before the learned tribunal and stated that the extent of disability suffered by the injured is 70%. Stop. The evidence of the evidentiary value of Exhibit 13 as well as the Exhibit 13 supported by PW3 before the learned tribunal has been well placed, and I find nothing immaterial or derogatory to disbelieve the evidence of PW3. So in this case, the permanent disability of the present injured is 70%. Is correctly assessed as 70%. Stop. Now considering the functional disability of the injured, comma, it appears to me that, comma, the injured has lost her opportunity to proceed her occupation as chemical engineer. However, the claimant injured has engaged in a job under the same company, though in a separate nomenclature, but considering the facts and circumstances of this case, I think it necessary to hold that the functional disability of the present injured should be equally to her disability as assessed by the doctors, that is 70%. Next slide. It appears to me that the compensation in favor of the claimant towards the non-pecuniary head was heavily challenged by the insurance company. Stop. Under the non-pecuniary head, the learned tribunal has awarded 5 lakhs towards the pain and suffering, and also awarded further 30 lakhs towards the cost of
At least more than medical expenses, not challenged for all.
yes, that would be no issue. Only challenge is the non-pecuniary. Only non-pecuniary
amount has been put.
Yes. For the cost of prosthetic limb and change of components of the prosthetic limb as well as future transportation charge in addition to the other components. It is true that the receipt of the receipt for the purchasing prosthetic limb of rupees 10,21,000 was placed before the learned tribunal, but was not correctly proved by the author of the said receipt. Full stop. It is not denied by any party that the injured was not using the prosthetic limb. Only the question is whether the cost of the prosthetic limb of rupees 10,21,000 is justified. So, it appears to me that there is no document or suggestion on behalf of the insurance company to say that the prosthetic limb or the cost thereof is less to that of the 10,21,000. Moreover, I find no justification to hold that the claimant is not entitled to get the cost of prosthetic limb. Thus, the cost of prosthetic limb and the change of its components in some interval, after some interval, is required. It further appears to me that the claimant has deposed that he used to expend rupees 12,600 per month for her transportation from her father's house to the office, to her office at Dalhousie. The learned tribunal has considered the same and has awarded the future transportation charges. Considering the entire fact, I find that the learned tribunal was justified in awarding the compensation towards the non-pecuniary. So, it further appears that the learned tribunal has awarded rupees 31,48,737 towards the cost of pecuniary damages, which was not challenged by the insurance company in this case. So under the above circumstances, it appears that the award passed by the learned tribunal requires modification. Only monthly income. Monthly income. Monthly income appears to be
20,000,
yes.
620. And annual income comes to that 83,440.
Yes.
Future prospect is 40%, 1,30,676. The total comes to 3,96,860. Multiplier is 70. These are
70.
70%. And medical expenses is 31,48,000. Whereas non-pecuniary damages, pain and suffering, and
35 lakhs. ongoing. Therefore, maybe just and proper compensation of this case. The just and proper compensation of this case comes as follows, or calculated as follows. Calculated as follows. The calculation to become monthly income. So after calculation, the hour comes to rupees 1 crore 13 lakh 70,000 847. Stop. The insurance company is directed to pay the compensation along with 6% interest per annum from the date of filing of the claim application, that is from 11/9/2015 till payment. So the insurance company is further directed to pay the above compensation together with interest.
Deposit already.
We have already deposited. Yes. How many deposited?
My lord,
1 crore 90 lakh 47,658 plus 20.
Total what happened?
Well, the total award, more or less with interest, comes to 1 crore 55 odd. So they will get some money back.
Now what they have deposited? Total deposit? Last কি বলেছিলেন? Directed to না আগের লাইনটা কি বলছে?
1 crore
1 crore
90 lakhs
90 lakhs
72,658
658.
19072,658.
Yes. কি বলছে আগের স্যার? (11/9/2015) till payment. Till payment. বাকিটা কেটে দেবো। আচ্ছা, it appears that the insurance company has already deposited the awarded amount by two challans, two OD challans, to the office of the learned, with the office of the learned Registrar General High Court, Calcutta, amounting to rupees 1 crore 90 lakh 72,658. Stop. The said amount must have accrued some interest. Full stop. The office of the learned Registrar General High Court, Calcutta, is directed to calculate the award passed by this court as above and disburse the same in favor of the claimant within 4 weeks. Full stop. After such payment, the residue appearing in the account of the insurance company may be returned to the insurance company along with accrued interest on usual prayer. Full stop. Next part. The DCF, everything has been sufficient. DCF was sufficient. Okay, next part.
এখন বলতে যাবেন না।
The insurance company is also at liberty to recover the entire amount of compensation from the owner of the offending vehicle according to the law laid down by the Honorable Apex Court in Saransi. Stop. Saransi, SWARAN. Your court fee is paid.
Yes, my lord, on the claim number.
In the award portion, it is there.
Yes.
Court fee is sufficient and paid. Your award was 1,28,000. So it was
1 crore
1 crore 28. Very good.
Receive granted liberty to recover.
Yes.
Yes.
FMA court disposal along with connected canal.
Yes. Other one means that
Yes.
Next item, my lord, is a for correction. Can it be taken up in for correction only? Other side is
What for correction?
my lord, only
Item
the
number 10.
amount, my lord, amount deposited by the insurance company. My lord, first time I'm saying apology, my lord, because my lord, it was once corrected, my lord, but even after that, the amount was wrongly taken. My lord, actually, insurance company deposited 90 lakh total amount. 56,000, 90 lakh, 56,937. My lord, these are the two challenge. And at first it was written as 19 lakhs, and thereafter, my lord, it was corrected and written as 91 lakh 34,937, which should be, my lord, 90 lakhs.
I could not follow. In the order dated 6th of February, 6th of February 2024, third line of the first page.
Order date 6th of February, my lord, amount was written as
Deposited, the already deposited the entire awarded sum of rupees 19 lakh.
90. It was, it should be, my lord,
90, 56, 937.
No, it was corrected.
it was corrected, but the
Corrected to be 91 lakh 34,937.
Yes, no, it was, but this corrected figure was also not showing the proper amount deposit, actual amount.
Actual amount is as per two challan.
How many times you will be correct the same
I am
issue?
saying my unconditional apology, my lord.
Again, you will come another day that the such correction is not
No,
correct.
my lord. Now, Mr. Paul has served, my lord, the copy of the challan, my lord. Kindly.
90, 56, 937 total amount.
First challan is for creditor deposit 25,000, and next challan is, my lord.
Then why you not calculate it? Quite amazing your submissions.
It was a mistake on my part.
One's mistake, another mistake, again one mistake.
Very sorry, my lord. Praying apology.
What should be the correct figure?
90, 56, 937.
Into. This matter appears for correction in the order dated 22/2024. The corrected figure would be read as 90 lakh 56,937 instead of 91 lakh 34,937. Remaining portion of the order shall remain unaltered.
91 lakh 56,937. That's correct figure.
It is not correct.
91 lakh 56,937.
তাই লিখেছেন?
And another matter, DA matter, my lord, can be taken on.
Do you want a seat for all day long?
No, no, my lord.
For you?
No, my lord, it can be taken up on.
What audacity you have? Take the time.
May I have your lordship, may I have your lordship's leave to mention an item number 5 and 6, my lord. My lord,
Yes.
in the item number 5, my lord, I am for the opposite party, my learned friend is for the petitioner. In item number 6, I am for the petitioner, my learned friend is opposite party. And my lord, whatever, my lord, I am engaged in the court of my lord, court number 1, my lord. So, my lord, I have got some personal difficulties. I'm not ready. Kindly, my lord, fix it another day. With the consent of my learned friend, my lord, I am mentioning this matter.
No, this item number 5 and 6, actually, it was not.
Yes, my lord.
Parted matter.
Yes, my lord.
It cannot be pending like that.
Yes, my lord, my lord.
Otherwise, we can dispose of it, otherwise it has to be released.
No, my lord, I beseech your lordship, my lord, before vacation, my lord, we will get it over. Well, my lord, much time, my lord. Hello, kindly fix
That's
it.
why I have keep it pending, because
Yes.
another matter was there that was disposed
Yes,
of,
yes.
and these two matters are there.
My lord, kindly, my lord,
These are
kindly.
actually parted matters.
Yes, my lord, do. My lord, kindly accommodate
You
us,
are
my lord.
ready to do this matter, that's why I keep it pending in my
Yes, my
list.
lord, my lord, I
It
will do
has
it.
to be disposed.
No, my lord, I will do it, my lord, I will do it, my lord. But my lord, my learned friend is also is eager to do it. My lord, kindly fix it, my lord. Sometime in the next month.
When can it be fixed?
My lord, kindly fix it in the next month, first week of.
No, first week of May, I have some.
Or
other
my
matters,
lord, before the
unfinished
vacation, my
matters
lord.
that has to be disposed of.
No, before the
These are the
vacation, my lord.
matters.
Before the vacation.
Some long pending matters are there, CBI matters are there.
My lord, it will
Mr.
not.
Bhattacharya is there.
Yeah.
These matters has to be disposed of
Yes,
before
my
the
lord, my lord.
vacation.
No, my lord, we also feel relief, my lord.
If it is disposed of today, I can dispose of it within 7
No,
days.
my lord.
But
My
otherwise,
let it be hard, my lord. Let it be hard. Kindly, my lord. My lord, this is a public interest litigation of.
difficulty is it was made parted, but it was not hard yet for any of the parties.
But my lord, it was parted. In fact, my lord, if
It was made parted by the another matter.
yes, my lord,
respect of another
it was hard several times, my lord. Interim order was there, etc., my lord. So many benches, my lord. It matter went to it. So my lord, in fact, it was not parted
And
before
you
it.
are good that you would dispose of it, you would conclude the matter. That's why I fixed it.
No, it was not parted before your lord.
When you are going to it.
Kindly fixed it, my lord. Some first
Now, who is petitioner in item number 5?
item number 5, my learned finish.
You are the petitioner, and you are the
I am the opposite party.
opposite party.
And next, my lord, I am for the petitioner. He is the opposite party.
So when can it be started?
Kindly fix it subject to your lordship's kind convenience, my lord. Well, we will finish it.
Today you are on 18th.
18th. First day week, my lord.
No, actually 25, 2nd, and 9. I have already fixed several matters.
Then, my lord, kindly any day subject to after 29.
May 23rd. May 23rd is the holiday.
Holiday.
Before vacation, just before vacation. Then come on 16th. 16th of May.
16th of May. Before the vacation, the matter will
Before the vacation.
And my learned friend will feel free, and I will be also feel free. We will get rid of the liability.
16th May.
16th May. Deep blue blessed. Hello, let my name is recorded because my name is not recorded. Hello, and in 5 and 6, my name is not.
Item number 5 and 6. Take down. The an accommodation is sought for on behalf of the party. The matter is adjourned today. Let the matter fixed on 16th of May at 2 p.m.
Well, my name is Chittaranjan Panda for the opposite party in the agreement. Deep blue. ওর নামটা আছে ওখানে নাম আছে ওটা ও দুটোতেই আছে
Call the matter. First matter 1 and 2.
Item number 2, my lord, I am praying for a day's accommodation. My lord, kindly keeps it up next week. My lord, the other side is also not here, my lord. Or
Where is
we
the other
finish
side?
it off. Try to finish it off next week.
What
my lord.
matter?
Conclude our submissions.
Mr. Ganguly has concluded, and thereafter, Mr. Some appearing on behalf
Mr.
of the
Banerjee was there. Mr.
Mr. Banerjee
Shivshankar
was there.
Banerjee.
Shivshankar Banerjee concluded.
That is in item number 1, my lord.
Item number 1. Item number
In
2,
item
you
number
supposed
2?
to start today.
Yes, my lord. My lord, kindly keeps it up next week, my lord. Next week, my lord, we'll conclude our submissions of that day itself.
Next week means
No,
25,
25th, my lord.
25th, 25th, 25th.
We will notify the other side as well, my lord.
25, I have some other matter. Very well, 25.
25th. Yes.
But where is the other side? You inform it, okay? Order for the 25th, 2 p.m. Next,
My lord, item number 3 and 4, I'm for the petitioner, my lord. I'm pray for short passover, my lord. Your lordship, I'm for the opposite party. I'm praying for not to speak. No, my lord. Mr. Arun Bhattacharya is appearing. My lord, he's stuck in court number 28. My lord, kindly short passover, my lord.
what happened in this matter? Mrs. Starling, holidays and this, sir.
Your Lordship, the respondent has already concluded their argument, Your Lordship. Today
Yes.
we are supposed to conclude it. Your Lordship, give me a short passover. Your Lordship, we will...
Opposite party has concluded.
Yes,
sir,
Your
then
Lordship. Yes, Your Lordship.
Today is fixed for reply.
Reply. We
on
will
behalf of the
conclude it
petition.
today itself. And we are ready with our notes also. We will
On
file
behalf
our...
of the petitioner. Only,
Yes, yes, Your Lordship.
only behalf of the petitioner. Only this party is.
Yes, Your Lordship. Your Lordship, give me a short passover. We will complete it today itself.
Yes, what is your sir?
Lordship, I was praying for not this week.
But Your Lordship, we are concluding
You
this.
have concluded. You
Yes,
have concluded the matter.
Yes, Your Lordship.
Let me hear out the
Yes, sir.
You don't have anything to say, but if you want to file any written notes of argument, you may. Okay, you may file. You take note. Okay. So after some time,
Yes, Lordship.
pass it over for some time.
Your Lordship, I am appearing for the respondent.
Yes.
The matter was, my lord, I have argued. Now, Mr. Mukherjee was arguing, Mr. Learned Advocate Obro Mukherjee.
No, they have concluded. I think they have concluded.
They have not concluded. Certain points on the last.
No, only the issue is that you supposed to file some judgments.
Yes.
He is supposed to file some written notes of argument.
Then your lordship in that event, your lordship kindly fix it. I will.
Some perhaps order is there.
I have not checked. I will be very honest with you, lordship. I have not checked the order. Last order টাইম দেখাবে তো বলো না কিছু না আপনার কোনো এ নেই তাহলে if he is concluded my lord then your lordship my lord kindly fix it. Both file a short written note of argument with judgments. My lord, the last order এটাই
The matter is part.
hard in part. Yes.
Nothing is specified.
Yes, so your lordship may pass an order, fix a date, my lord, and direct both of us to file written short written notes of argument with the relevant judgments to the Samanta. That can be done. No, I don't do it.
Where is Mr. Mukherjee? He's supposed to be here.
সেটা দাও নি তো
Mr. Obro Mukherjee, my lord. Well, may I just see? Well, I'll just see, my lord, if you can.
Oh, another thing rightly pointed out by my learned junior one copy, your lordship requires.
Yes,
that compilation.
Yes, I want your.
That is missing in your lordship.
Yes, yes.
Your lordship, thank you.
Substantial argument has concluded.
Yeah.
So you supposed to file today the written notes of argument, and in reply the CBI also intend to file written notes of argument with some judgment.
Yes.
Then, my lord,
Otherwise,
5 minutes passover minutes, yes, coming. 5 minutes. 5 minutes.
no, I shall not give any time for written notes of argument. I will fix heavy,
My lord.
and you may file the written notes of argument within 15 days. Within 15
Yes,
days.
yes.
Within 2 weeks. I shall mention.
Within fortnight we will file.
With the
My lord, give me 5 minutes passover seniors coming, my lord. You
Very
will
well.
submit something, my lord.
okay, let's senior.
Very
Very. Yes.
Well, I'm sorry, my lord, 3 and 4, my lord, those matters, my lord, where they had, the complainant was the son of the de facto complainant, my lord. There is a FIR, there is a complaint case, my lord, that, right, my lord, after 27 years, my lord, they have filed these proceedings. My lord, we concluded our part. They had also concluded their part. But we have prepared a short note, my lord, and we have prepared a compilation of judgment. Now, my lord, whatever we have argued before your lordship, my lord, those things are incorporated here. But
Yes.
unless you
have a copy.
my lord, I'll have a copy in course of this day. Unless you, my lord, I'm right now, my lord, I'm sorry. My lord, unless your lordship has a specific query, my lord, I don't want to trouble your lordship. Because your lordship has seen the proceeding, my lord. There is a consumer forum by the father, complaint case by the mother, FIR by the son, and all things, my lord, the book they booked. Either so far mother is concerned 96, 97. So far son is concerned, my lord, 1992. One proceeding after 21 years, another is after 27 years, my lord. And in any case, my lord,
Corvette, like.
I'm obliged to your lordship. And in any case, my lord, now the Honorable Supreme Court has said criminal proceeding cannot be a recovery proceeding. And the judgments they have relied on, my lord, one of those judgments, my lord, I'll be also relying on IOC, Indian Oil Corporation, where there is a paragraph, my lord, where the Honorable Supreme Court succinctly laid down that there is a tendency presently to convert all civil proceedings into criminal proceedings. Now, my lord, now that tendency reads large. It's more. And that was the judgment of Justice Dhulia, my lord. I have given those judgments in the note, my lord. Unless your lordship has a specific query, my lord, I don't want to trouble your lordship. And so far that I know, my lord, and so far FIR is concerned, there is non-compliance of 154.1, 154.3, not according to Mukul Rai. But my lord, I think this is a matter where we had argued on substance because this is a clear abuse of process of law. So form will take secondary, my lord. Will take backseat when in substance they could not make the offense, my lord. What I will beseech, my lord, your lordship may make these two matters, my lord, CAP.
So,
And I'm seeking quash matter.
Can we be given a week's time to file our return notes?
Yes.
Your lordship may make it CAP, my lord, they will file in the meantime, they will give us a copy. But we have filed one combined note, my lord, for both these matters.
Yes, yes. Okay, please take down. Combined written notes of argument on behalf of the petitioners, along with the copy of judgment, so it's placed on record. Stop. Let the matter placed in CAB. Stop. The opposite party is at liberty to file written notes of argument within a week.
Most grateful. And my lord, my apologies, my lord, when the matter was called on initially, my lord. Most of it.
Mr. Mitra, you have handed over.
I had handed over the compilation. Yes, which was earlier handed to you.
Yes, during your argument. During your argument.
Yes, during my argument.
During your.
I'm paying leave before your lordship 2 weeks time to file written notes of argument with the relevant judgment. This is, my lord, compilation of the statements which we are
Compilation of
particularly- yes,
statements of available witnesses.
Yes, yes.
Recorded under section 161 CRPC. And you have also annexed the statement.
Yes. This is nothing new. It is a compilation of statements.
Yes, yes.
Charge sheet has already been given to standard.
You have also.
My endeavor before your lordship would be, my lord, that whether at this stage, before my lord going a full-fledged trial, whether your lordship can, my lord, look into which version of the prosecution case is correct or not as a mini trial.
Yes.
Yes. When prima facie, my lord, charge has been very well established against the accused. So far, his main contention was that I am not only the responsible, because after me, there are other bank officers in my post as I
Was the
understand.
manager when
Yes,
the
when the loan was
OCC was sanctioned,
correct, when
two
the loan
OCC was
continued.
sanctioned,
Yes,
thereafter it was continued
correct. But that is
year after
that
year.
why the other bank officers are not being arraigned as accused.
No, that is not the issue.
Not
Issue
the
is that
whether
whether
he,
he is responsible for any fault,
yes,
any criminality is there or
yes.
not. This is
And
has to
so
be
far,
looked
your
into.
lordship, remember in this case the mortgage properties which has been mortgaged for the second time.
Earlier in the
Yes, that
it
is
was
clear,
mortgaged
my
in
lord,
the
clear case of
Howrah Bank like
treaty.
that,
Yes, yes,
in a bank of Howrah.
yes.
No, whether you must argue
Yes,
or
I will argue.
you must argue or file written notes of argument on the point they have raised
Yes, I will argue
regarding
on
the
that.
bank manual
Absolute,
and the statements they have
Yes,
mentioned it.
yes,
You just specify your argument
yes,
or
yes,
written notes of argument regarding
yes.
these.
And also I will argue, my lord. So you
No,
not,
no,
not
necessary.
necessary.
Not
Very
necessary.
well.
You just specify
Very well. Your
in your
lordship
written
kindly
argument.
give me 2 weeks time. I will.
Okay.
file
What is
that.
your sense?
Give us
2 weeks time. Very good. Please take down. The compilation of statements of witnesses of charge sheet witnesses along with their statements is placed on record on behalf of the CBI. Full stop. Argument on behalf of the parties concluded. Made CAB. Stop. The parties are at liberty to file written notes of argument within a fortnight. Interim order passed by this court. The interim order passed by this court on the earlier occasion is further extended till the disposal of the instant CR.
Good.
All in? Yes. Thank you.